Good morning, sir. May I call Professor Dame Sandra Dawson and Dr. Katy Steward, please?
Certainly.
Repeat after me, please. I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Please take a seat. Repeat after me. I do solemnly, sincerely and truly declare and affirm
that the evidence I shall give
shall be the truth,
the whole truth,
and nothing but the truth. Please sit down.
Good morning, Dame Sandra and Dr. Steward. My name is Jason Beer, as you know, and I ask questions on behalf of the inquiry. Can you each tell us your full names, please?
Sandra June Noble Dawson.
Katy Mary Steward.
Thank you very
I
much.
should say before you start, Mr. Beer, that nothing ever surprises me in this life. It's taken more than 50 years in the law to see two persons in the witness box at the same time.
I was about to say that trained observers will notice that there are two witnesses.
Well, I'm on the ball this morning to see that.
Unusually.
Thank you.
There was another part to that sentence. Unusually, we have two witnesses in the witness box.
Yeah.
And I should therefore set out the process that we intend to adopt when asking questions of the witnesses, and indeed, please, when call participants ask their questions, which is going to be tomorrow. The purpose, sir, of setting out these ground rules now is to ensure the orderly and efficient receipt of evidence from the witnesses in circumstances where the witnesses are giving evidence currently. So the ground rules, if I may. Firstly, the questions that I will ask you, Dame Sandra and Dr. Steward, in a moment about the signing of your reports and whether the contents are true will be asked of you individually. Secondly, the questions that I shall ask in a moment about your qualifications will be addressed to you individually. But third, however, questions that will be addressed to you collectively thereafter, it has been agreed that you, Dame Sandra, will, in the first instance, address each of them, either by providing an answer or inviting Dr. Steward to answer. Fourthly, we'll work on the basis that Dr. Steward agrees with Dame Sandra's answers, unless she agrees otherwise or wishes to intervene. The aim of that approach, sir, is to reduce the possibility of discussion in the witness box, and also to ensure that we've got a clear record of the evidence that the witnesses give collectively. So the reports. You've prepared two reports. I think the first is dated the 26th of March 2024, is 133 pages long, including its appendices, and the second is dated the 29th of October 2024 and is 154 pages long, including its appendices. You updated both reports recently in large measure to correct formatting and referencing issues, and both reports were reissued yesterday. It's those reissued reports that we're going to use in the inquiry today and tomorrow. So the first report, can we have it on the screen, please? EXPG 606_R, and you should have a copy of that in front of you as well in hard copy. You'll see from the title page, 26th of March 2024, it's the first report, report 1, updated 11th of November, i.e. yesterday. And can we go to page 133, please? This is the expert witness declaration and the statement of truth. Those are redacted in the copies that we have. But to start with, Dame Sandra, is that your signature?
It is.
And are the contents of that first report true to the best of your knowledge and belief?
They are.
And Dr. Steward, is that your signature?
It is.
And are the contents of that first report true to the best of your knowledge and belief?
They are.
Thank you very much. Can we turn to the second report, please? EXPG 5010_R. You'll see this is headed second report. It's dated the 29th of October 2024, and it was again updated yesterday, 11th of November. I think there are some corrections to make even to that. Can we look, please, to start with at page 33?
I think I better stop you there because the neither assessor is having these things on their screen at the moment. I've got it, but they haven't. So that needs to be fixed before we go any further, I think.
Yes, I'll just pause, and usually somebody from RTS appears. That's not going to happen on this occasion, so we need a 5-minute break to correct the position. So can I ask you to rise for 5 minutes? We'll all wait here.
Yeah, we'll go out. But if you don't mind sitting there to save coming back and forth, I'd be grateful.
Thank you, sir. Thank you, sir. Take two. Can we go to the second report? We were making some amendments. Page 33, please, if that can come up on the screen. And paragraph 114, in the second line, should we cross through the words and then into the third line, investigations? Is that right?
That is correct.
James Sandra, thank
Now
you very
it's
much.
correct.
Page 48. Paragraph 176. Two corrections. In the third line, into the fourth line, should we omit the words "and investigations" that are being highlighted on the screen? And should we omit the words "investigation and"? After the word or the acronym SPM. Is that right?
That is correct.
Thank you very much. And page 60. Paragraph 222, in the quotation in italics, 3 lines from the bottom, should we replace the word "about" with the word "that"? Is that correct?
Correct.
Thank you very much. And then lastly, page 99, paragraph 370. In the second line, should we insert the word are between the words there and no, so that it reads, and consistently be done, sort of, if there are no decisions? Yes?
Correct.
Thank you. Can we go to page 154, please? And scroll to the bottom. With those, well, firstly, is that your signature, Dame Sandra?
It is.
And with those corrections brought into account, are the contents of the report true to the best of your knowledge and belief?
They are.
Thank you. And Dr. Steward, is that your signature?
It is.
And are the contents with those corrections brought into account true to the best of your knowledge and belief?
They are.
Thank you very much. Can we go back to the first report, please, and turn to your qualifications, expertise and experience? It's first report at page 131. Thank you. Starting with you, Dame Sandra, I think on the first two-thirds of that page, your qualifications, experience and expertise are set out.
Yes.
Can I summarise the important parts? Tell me if you agree. Firstly, you have taught, researched, written and consulted on organisational behaviour, leadership and governance.
Correct.
Secondly, you held academic posts at Imperial College London in the University of London before moving to Cambridge.
Indeed.
At Cambridge, you were the Master of Sydney Sussex College, a Deputy Vice-Chancellor, and most relevantly for us, the Director of the Judge Business School for 11 years between 1995 and 2006.
Correct.
You're now Professor Emerita at the university.
Correct.
In addition to your academic interests and the positions that you have held, you have personal and practical experience of organisational behaviour, leadership and governance, and you set that out in that substantial paragraph that's at the foot of the page that we're looking at now. Just picking out some highlights, I think you've been the chair of an NHS trust.
Correct.
You have been a senior independent director, a SID, and chair of a remuneration committee.
Correct.
That was at TSB. You have been a NED, a non-executive director, and a member of an audit committee. That was at both Barclays PLC and JP Morgan.
JP Morgan Claverhouse Investment Trust.
Thank you.
Yes.
You were a member of the Senior Salaries Review Body.
Correct.
You have been a non-executive director and a senior independent director at a public body, namely the Financial Services Authority.
Correct.
Thank you. Dr. Steward, staying with page 131, if we scroll down, please. And this goes over to page 132. This sets out your qualifications, experience and expertise. And can I summarise? Firstly, you have taught, advised, coached and consulted in leadership, organisational culture and governance for 30 years.
Correct.
You were the head of the National Culture and Leadership Programme for NHS England.
Correct.
Thereafter, a visiting fellow at the Cambridge Judge Business School and now a visiting scholar at Sydney Sussex College, Cambridge.
Correct.
You have also served on the boards of public sector bodies and charities, including an NHS trust and the UNHCR.
That's great.
Thank you very much. That can come down. Can I turn to the third topic then, the methodology that you deployed in approaching your task and the purpose of each of your reports. If we can turn to page 6 of report 1. Thank you. Does this set out a summary of your instructions?
It does.
Thank you. And in summary, this report, report 1, was prepared and completed, remembering it's dated the 26th of March 2024, before we commenced hearing any evidence in phases 5 and 6 of the inquiry. That evidence started on the 9th of April 2024. And so it's unaffected by any of the evidence that we were subsequently to hear about what actually happened at the post office, what happened in the exchanges between the post office and UKGI, and what happened involving UKGI and before it the shareholder executive and central government from 2000 onwards. Is that right?
That's correct.
In paragraph 1, in Roman 1 there, you say we're instructed to provide a report which sets out what might typically be expected stroke best practice. And in paragraph 2, in the second line, you say that the report deals with generally expected standards. Do I understand correctly that the standards which you say ought to have been achieved in this period do not represent, in your view, a counsel of perfection?
That's exactly right. The standards are ones which are generally expected. They're not the highest level or the lowest level.
So there, is this right, the standards reasonably to be expected from a company in the position of the post office?
Indeed.
Thank you. Looking at Roman 3 and 4, you tell us that Annex A to your report, your first report, provides a chronology of the laws and guidance on governance of companies which applied during the relevant period, 99 to 2019, presented chronologically, split into columns, left-hand side are the requirements and guidance which apply to companies, special attention paid to publicly listed companies, right-hand side are the requirements which apply to companies and other entities which are wholly owned or controlled by the government. And you say, and we're going to look at Annex A in a moment, whilst there are differences between publicly listed and publicly owned companies, it's notable that in matters of governance during the relevant period, one finds the requirements and expectations for all organisations in the UK have tended to be encouraged by governments and regulators to follow the approach adopted in law and guidance for publicly listed companies.
That's correct.
So if we can look at Annex A, I'm not going to go through the detail, but just want to establish how it works. It begins on page 93. Now, if we scroll down after the preamble, we can see the two columns that you mention. One is headed formal legal requirements for corporate governance, and then on the right-hand side, formal legal requirements that would apply to public corporations and companies in government.
Correct.
And you essentially track across time. We can see on this page 1998 and 2006. And if we go over the page and keep scrolling, and keep scrolling, nothing relevant in 93 and 94, for example. So that's the way the thing works. If we can go back, please, to page 93 and look at box 1.1 and 2.1. Thank you. Here you note some of the requirements of the Companies Act, Companies Acts in 1995 and 2006 on the left-hand side that applied to companies, and then on the right side, public corporations or companies essentially in government ownership. Is that right?
That's correct.
And you note that the Companies Act on the right-hand side covers companies in government ownership, i.e. incorporated companies in which the government is a large or sole shareholder.
Indeed.
And so you're essentially suggesting that we should read what we read in the left-hand box into the right-hand box. Is that right?
Indeed.
Thank you. Can we look at another example of how this works by looking at page 100? And scroll to the foot of the page, please. And look at paragraph 1.8 and 2.3. 1.8, left-hand column, normal companies. Right-hand side, companies in government ownership. And you point out there that in relation to ordinary companies in 2005, there was a revised revised guidance on the combined code.
Indeed.
In the same year, issued by the Treasury and the Cabinet Office, a corporate governance code in central government departments.
That's correct.
It is, just by way of detail, that what's recorded in box 2.3, the first occasion on which government issued a corporate governance code.
Yeah.
And so the first time that there was a formal document issued by government about government-owned companies was that issued by Treasury and the Cabinet Office in 2005.
Yes. You'll note that there was, in 2001, we've noted the Management of Risk, a strategic overview, rapidly which became known as the Orange Book, which had, we thought, some relevance.
If we go
Which
back
was in
to that,
2001.
yes, we go back to that. That's on the top
Yep.
of page 99.
Yeah.
You were referring to the Orange Book. Was that principally about risk management for accounting officers,
It was. Yeah, it was about the management of risk.
rather than the broader subject of
Indeed.
corporate governance?
Indeed.
Thank you. So that's how Annex A works, and that will be an important source of material for the inquiry in due course. I'm not going to go through it. It speaks for itself. Can we go- Yes,
May
of
I
course.
add that on page 94, we've moved from formal legal requirements into codes and guidance, which I think you didn't
I skipped
directly. Yes.
over. Thank you. You're right to pick me up. The second person that's done that this morning. Page 93, just so we can all understand what you're speaking about. The two headings there are both about formal legal requirements. They both start in that way and address law, i.e. Primary legislation and Act of Parliament. And then over the page to 94, and scroll down please. Essentially new headings maintaining the same approach. Left-hand side companies, right-hand side companies in government ownership. Here dealing with other instruments, codes, guidance and similar documents.
That's correct.
Thank you very much. Can we go back to page 6 of your first report, please? You'll see in Roman 6 at the foot of the page, you say, beyond identifying specific requirements and guidance for governments, as summarised in that table we've just looked at, we've commented on what might normally be regarded as known reasonable practice in governance, management and leadership. That commentary is based on our experience and expertise. Just so that I understand what you're saying there, you're saying that part of your report is founded on law or one of the other instruments summarised in Annex A, but other parts of your report are not founded on such instruments. They are based upon your experience and expertise.
That's correct.
You then set out, if we go over the page, please, over 8 chapters, the headings of which are set out there, your views on what might reasonably be expected of a company in the position of the Post Office between 1999 and 2019.
That's correct.
Thank you. This does not comment, Report 1, upon the extent to which those standards reasonably to be expected of the Post Office were in fact realised.
Makes no comment.
Thank you. Can we go to Report 2, please? Apologise for the delay. The system's taking a little while today. And turn to page 6. Here you set out your approach, your methodology in relation to Report 2. And this report, is it right, was prepared in the course of and then after the evidence was heard in phases 5 and 6?
That's correct.
You tell us in paragraph 2 that it wasn't your intention, nor indeed were you instructed, to establish any matters of fact. In paragraph 3, you tell us that you have applied, you have been mindful of the standards of expected behaviour that you set out in Report 1. That is, I've used the language within the inquiry in the past, Report 1 as being essentially the highway code of corporate governance. Is that an unfair description of it?
That's entirely right. And in relation to Report 1, the concluding Section 8, as we identify there, also includes a commentary on what it's like to experience organisations, particularly in relation to authority, power, leadership, culture and communication.
You tell us in paragraph 4, by way of reminder, what Annex A, an important document of Report 1, consists of. In paragraph 5, you say that the instruments you mention provide the foundation for considerable consensus reflected in the large volume of written and broadcast advice on what makes for good board governance and executive management. What was the point you were making there, that the volume of material?
Yes, one might have expected expert evidence from an academic to be replete with references. The truth of the matter is that there is an enormous amount which is written and expressed about management, leadership and governance. There is a general consensus which may be available at any bookstall or advice from a professional services organisation, and we felt that that consensus was sufficiently strong for us to rely upon it.
Thank you. You tell us in paragraph 6 that in preparing this second report, you drew on your reading of your selection of the evidence, including excerpts from witness statements and transcripts of oral evidence, and I think reading some of the underlying material.
That's correct.
The primary documents. And you tell us in paragraph 7 that you reviewed that evidence and yourself chose 3 case studies for analysis.
Correct.
And am I right in believing that those case studies chosen for report 2 do not represent the entirety of any view on the propriety of the Post Office's governance over the time period relevant to this inquiry?
That's correct.
Instead, they're prepared to assist the inquiry, but do not reflect any conclusion of the entirety of any good or bad practice in the governance of the Post Office between 1999 and 2019.
That's correct.
You tell us that in being selective, the third line of paragraph 8, of themes and evidence, you appreciate there may be additional alternative constructions based on the body of evidence before the inquiry, which we have not considered. Can you explain what lay behind that sentence?
The vast body of material before the inquiry was such that we made a selection, but there may be people who will think, well, they should have looked at this or they should have looked at that, which we didn't do.
And so you're telling us that even in the case of the case studies, the examination of the material has not been exhaustive, i.e. looking at every document?
We cannot know.
Can we turn, please, to pages 8 and 9? This sets out the scheme of your report. Is this a fair summary? If we look at page 9 first, you looked at 3 case studies. The Wolstenholme case in 2004, the consideration of the second site interim report by the Post Office Board in 2013, and the handling of Simon Clark's advice, or one of them, by the Post Office Executive in 2013.
Indeed.
Those are the 3 case studies. And can you help us, why did you pick those 3 case studies?
We reviewed, in general, the material that we had before us. We considered our instructions, and we thought as illustrations, those case studies were ones that we would wish to go into some depth with. At the beginning of our work, we were more optimistic, and we thought there may be indeed other case studies, but we were only able to do 3.
And then if we go back to page 8, please. You say in paragraph 13 that the overview provides a thematic summary of your observations on the Post Office's board governance and executive management and organisation, which are based largely on the description and analysis of the 3 selected case studies, informed by a wider reading of a selection of evidence before the inquiry. And then you identify your themes, and if we just scroll down, are they split between themes that relate to essentially governance by the board, and then themes that relate to the executive for its part?
That's correct.
And so the first 6 relate to the board, and then if we scroll down, please.
Yes.
The remaining 3 relate to the executive.
That's correct.
So just pausing there, approaches 3 case studies across time. We've seen 1 in 2004 and 2 in 2013.
Yes.
using those as your evidential base, you've identified or isolated 9 themes,
Correct.
6 of which relate to board level governance, 3 of which relate to management and organisation by the executive.
Indeed, correct.
While there are no case studies picked up by you between 2004 and 2013, that does not mean that there are no questions of governance arising for you. Is that right?
Neither before 2004, nor between 2004 and 2013, nor subsequent to 2013.
So we shouldn't take from that that there are no questions of governance arising which the inquiry therefore shouldn't look at. The inquiry should look at those by reference to firstly the principles that are derived from your first report, but secondly from your analysis of the 3 case studies and the themes in your second report.
That is exactly the case.
Thank you. That can come down. Throughout this second report, you identify actions on the part of the executive, the chief executive, the chair and the board, which amount, in your view, to a failure of governance.
We identify a number of things which we believe are indeed a failure of governance. Governance, of course, is a series of processes, structures, systems, and rules underpinned by behaviour and culture. And therefore, where the failure exactly occurs in that overall network of structures, systems, processes, behaviour and control, we hope we've indicated. But failures of governance be many things.
What does, in inverted commas, failure, in inverted commas, governance failure, or failure of governance mean?
When one's concerned with the governance of organisations, you're concerned with the structures, systems, processes, behaviour and culture which will secure the governance and management of the organisation in the best interests of that organisation. And therefore, if one identifies a failure, it is that it does not appear to be, to us, to be in the best interests of that organisation to pursue its purposes.
And also a failure to meet the reasonably expected standards of good governance identified in Report 1.
And that was the basis on which I made my prior comment.
And so where, in each case in Report 2, a failure is identified by you and Dr. Steward, that would have been a failure according to the standards in play at the time.
Indeed, in our belief.
And so to take an example, if there were facts on which it might reasonably be concluded that the chief executive or the chair or members of the executive had critical information about risk that was not provided to the board, you could break down by reference to the law, the policy or the guidance identified in Report 1, how that would in fact be a governance failure.
Indeed.
I think it's right to say don't do that on every occasion.
We don't.
Because you've already identified in Report 1 what the relevant standards are.
Indeed.
And so where we read failure of governance, governance failure or failure, that's to be taken as a reference back to the standards in Report 1.
It does, absolutely.
And so in the scenario I've just described, the failure to provide relevant information about risk by a member of ExCo or the CEO to the board, there could be a possible breach of directors' duties in the Companies Act.
It could be.
It could be a breach of duties at common law, or it could be a failure to adhere to reasonably accepted standards in a corporate governance code.
Indeed.
It might indicate a possible failure in the relationship between one of the individuals and the board.
Indeed.
Can we turn, please, to report 1 then? And I want to try and deal with this briefly if we can. And start by looking at paragraph 1.2 on page 8.
1.2.
On page 8. And so just to remember, report 1 has 8 topics, and this is topic 1, governance, principles and codes. We see that from the top of the page. It might be helpful if you just, this chapter runs for, I think, 12 or 13 pages up to page 20. Could you, in a paragraph or two, describe the sort of the purpose or the coverage of this chapter?
We were eager to lay out the historical context and how that had then developed into codes of practice. We identify that in a way, the roots of governance were around protecting the rights of shareholders, which became very important when you got a split between ownership and control. And the question was, how were the executive, who no longer owned the business, going to be held to account, and who was going to hold them to account? And that led to the formation of boards, and in time, particularly in relation to the development of contemporary governance, the work that followed the Cadbury Committee, which then became, that was in 1992, and then together with Greenbury in 95 and Hampel in 98, became enshrined in the combined code on corporate governance, which really is the first time that these matters have been brought together, which dealt with the need to separate the chief executive and the chair, and which identified roles, specific roles for non-executive directors. And in the subsequent 25 years, that combined code from 2010, understood as the UK Corporate Governance Code, has increasingly identified areas beyond roles and responsibilities, dealing, for example, with audit, dealing with risk, dealing with the need to disclose certain matters with relation to conflicts of interest, and then latterly matters to do with diversity, equality, and inclusion and other societal aspects. What can be seen, I believe, from Annex A is that this is an evolving story, and I'm mindful that the inquiry is dealing with 20 years of that evolving story, and we've tried to be careful to look at what would have been contemporarily expected at the time.
Thank you. If we just scroll down on this page, just some terminology. You tell us in 1.2.1 that UK practice is to have a unitary board of executive and non-executive directors. That is opposed to what? That is opposed particularly if one looks to organisations in continental Europe, where there is often a two-tier board, the overseeing board, which will have a representative of a larger number of stakeholders, and the executive board, which is responsible for running the business. In the UK, the custom has been for the executives and the non-executives to sit together, and it's normal that the chief executive and often the chief finance director will sit as board members as well as having their executive responsibility. And in that sense, it's called a unitary board. Thank you. And in 1.2.3 at the foot of the page, you tell us what you have just mentioned about Cadbury, Greenbury and the Hempel committees becoming enshrined in the combined code, which you told us was called the combined code up until 2010. Correct. After which time it was known as the UK Governance Code. Yeah. Or Code of Governance. In what sense was it combined?
I've often wondered that. It was combined in the sense that it amalgamated these different reports from different committees and these different expectations of governance. That word combined is just asserted.
Thank you. If we go over the page to page 9, you tell us that that code in 1.2.4, through its principles and provisions, gives a well-established base set of regulations and guidance on the two things that you mentioned there, the structure and operation of boards of directors, including the roles and responsibilities of chairs and chief executives, and the roles and responsibilities of shareholders, particularly institutional shareholders with relatively large shareholding. So is the point that you're making there that this code, across the entirety of the period that we're looking at, was an easy to find instrument which set out a detailed and a well-established base of guidance?
I'm afraid I didn't hear the word you said before, set out something detailed.
And well-established set of guidance on the two things that you mentioned.
Indeed, that's correct.
And so the point, is this right, that you're making, is that one doesn't have to search very far. It's not a voyage of discovery to find out what corporate governance standards and principles were in this period.
No, absolutely not. And I think the coming of Cadbury was really a very momentous period for UK governance. As we've seen in relation to Appendix A, government itself looked back and looked at commercial organisations and said, these standards, they should indeed apply as best they can to those organisations. Charities similarly looked at them and thought they should apply. Other private organisations began to think, these criteria, these recommendations, these principles are basic and sound, and we should apply them.
In terms of the duties to comply, you tell us in paragraph 1.25 that boards in their annual reports have either to complain or explain why in their special or individual circumstances the code's requirements are not, in their view, appropriate or advisable in the circumstances.
They may indeed complain, but they're required to comply or explain. So if, for example, it says the chair and the chief executive should have separate, should be separated, no one man or woman should hold them both. There were some organisations where it was felt by the board that it was appropriate in their circumstances that they should be combined, in which case in their annual report they would have to explain why it was in their particular circumstances they were not complying.
Thank you. Can we go over to page 10, please? And look at paragraph 1.3 at point 1. You say that it's become increasingly accepted that corporate governance codes for commercial companies offer guidance for to other forms of ownership, notably, and then C, which concerns us, publicly owned assets where the owner is the national government or local authority, and a major element of funding comes from the taxpayer, sometimes in combination with revenue from commercial activity. The governance of such publicly owned companies is central to our instructions. So is the point that you're making there that what we read in the combined code and then the UK governance codes should be something which is applied to a company which has publicly owned assets?
That's indeed the case, and government frequently asserted when looking at different public bodies that the expectation was that insofar as was appropriate for their circumstances, these codes and principles should apply.
Thank you. Can we look at the foot of the page, please? Which is, I think, the point you've just mentioned. You say in 1.4.1 the government has drawn on corporate governance for publicly listed companies to provide a framework for how the governance of an array of public bodies should be governed. And then I think you quote from the Treasury publication that we looked at in Appendix A, good corporate governance is fundamental to any effective and well-managed organisation, is the hallmark of an entity that's run accountably and with the long-term interest clearly in mind. Is that right? That's one of the pronouncements that you rely on to support the assertion that our government has suggested compliance with the corporate governance codes for companies in public ownership.
That is correct.
Thank you. Can we go forwards, please, to page 15? You start off here dealing with what you describe in the cross-heading above 1.6.2 with 4 levels of accountability.
Yeah.
I find this a little complicating. Can you explain, firstly, the 4 levels of accountability, are they levels that you have designed or thought of in connection with the post office?
They are our invention of trying to make sense of who was accountable to whom at different stages of the period, the relevant period. And that's why in Appendix B, we identify each of the levels. So I'll explain each of the levels. The first level is who was accountable for running the post office business.
Sorry to speak across you there, Dame Sandra. I'm going to come to Appendix B in a moment. I just want to work out at the moment what these levels of accountability are. So firstly, they're not a concept from corporate governance, academic research that everyone in the corporate governance world would know, the 4 levels of accountability. They're your design for this problem.
They are our design for this problem.
Okay. And if you then just talk us through level 1, POB, the post office business. Here you start appealing to lawyers by using these acronyms. But the post office business, just explain what that level is, please.
That is the level which is running the post office business, including, for example, the sub-postmasters network and matters connected with Horizon. Okay.
And then if we scroll down, please, to 1.6.4, the second level of accountability, OPOD, the intermediate ownership of the post office business. Can you summarise that for us, please?
This is the level above the post office business, so very initially the Post Office Authority, and then in that period when the post office was was a subsidiary of variously called Royal Mail Holdings and other holding companies. This was that intermediate ownership level, so it was the ownership of the post office business.
Thank you. And then level 3, AGS, active government shareholder. Can you briefly summarise this for us?
Yes, that is where the government as shareholder identified its role and required some accountability from both the post office business and the intermediate ownership of the post office to that shareholder.
And thank you. And then over the page, level 4, the government, the 4th level, if you can briefly explain that for us.
Ministers and senior civil servants in the relevant sponsoring department on whose behalf investors were providing oversight.
Thank you very much. And then the next part of your report deals with what you describe as 3 phases in accountability. So this is essentially a chronological account across time between 1999 right up until 2019, which is your relevant 20-year period. And so if I can understand what's going on here, is it right to say that you then looked chronologically at how the four levels of accountability applied across time and split that broadly into 3 periods, 3 phases?
That's correct, and the periodicity was our construction again.
Thank you. And so phase 1 is between 1999 and 2001. And what you do is then you narrate for us in 1.6.8a what level 1 was and its relationship to level 2, taking us back to your concepts.
Indeed.
And then if we scroll down, please, and over the page. And then in B, at the top of the page, level 2 and its relationship with level 3. That's because there was no, level 4 rather, that's because there was no level 3 at that stage.
Indeed.
And then phase 2, again, you're essentially applying these 2 dimensions, levels across time.
Indeed.
And tell us in 1.6.9a what level 1 and its relationship to level 2 was in this 11 or 12 year period. And in B, levels, the relationship of levels 1 and 2 to 4, and the relationship of levels 1 and 2 to 3.
Indeed.
And then over the page, please. The last phase, the 6 or 7 year period between 2013 and 2019. In A, tell us about level 1's relationship to 2, the relationship of 1 and 2 to 3 in B, and then over the page. And scroll down, please. Level 3's relationship to level 4.
Indeed.
And so what you were trying to do, is this right, is bring some sense to a changing picture of corporate structures with either more or less intermediate levels between levels 1 and level 4 across time.
That's exactly correct.
And is that represented in more detail in Annex B of your report, starting at page 112?
That was our intention.
If we turn that up, please, page 112. And so this is, rather than setting out essentially in narrative format, which is what you did in the body of the report, the phases and the levels, this seeks to combine the pair of them in a table. Is that right?
That is correct.
And this is for real aficionados. If we look, for example, in phase 1, 99 to 2000, we can see in 1999 the existence of levels 1, 2 and 4, but not level 3 as you've just described. You have described the nature of the entity at levels 1, 2 and 4 as respectively Post Office Counters Limited, and you've put the company's number, it's how it was incorporated, and the fact that it was a subsidiary of the Post Office Authority, which was a statutory corporation. You tell us in about the 5th column along, a statutory corporation with power to issue directions to the Post Office. The sponsoring department was the Department of Trade of Industry, the DTI, and the Secretary of State was Stephen Byers.
That's correct.
And then if we just scroll down, we see that you track that across time from the year 2000 on that page, 2001 into phase 2, the second period, from the following page, and so on.
That's correct.
And so this is a 2-dimensional representation in tabular format of the concepts that you have isolated, i.e. what is the overall corporate structure at 4 levels, and how did it change across time?
That's correct.
Thank you very much. Was there any relevance or significance to these, what might be described as shifting sands of corporate identity across time?
The relevance for us was that the essential part of governance is accountability. To whom am I accountable for what? And therefore it was very important to understand that accountability in overall terms that was based on the corporate structure.
Thank you. Well, that's very valuable work, if I may say so, and will be of use to the inquiry in due course. I'm not going to go through the many pages of the table because we've got them.
Thank you.
Can we go back to page 20 in the body of the report? And 1.6.11 at the top of the page there. You summarise this exercise by saying, in conclusion, based on the guidance in Annex A, which we've looked at in summary to see how it works, and the information available to the authors as summarised in Annex B, which we've looked at in summary, from 2001, one would expect governance structures in levels 1 and 2 to be modelled on the corporate governance of commercial companies with a fully functioning executive and, where applicable, board structures, including non-executive directors, board committees, etc., whilst also paying regard to aspects derived from their public ownership by government.
That's correct.
Thank you very much. So we've been going for an hour and 15 now, even despite the break. Might we take the morning break now until 11:30?
Certainly.
Thank you very much.
Just give them a second or two.
Will do, sir. Can I turn, Dame Sandra, Dr. Steward, to chapter 2 of your first report? That starts at page 21. This chapter runs from pages 21 to 35 of the first report. It's under the heading of accountability. Can you describe for us in a paragraph or two the purpose and coverage of this chapter of your report?
Accountability is at the heart of governance. It explains to whom am I accountable for what. Governance is about relationships and responsibilities. So if I am responsible for doing A, who is going to see that I exercise that responsibility? To whom am I accountable for doing that? Accountability is formal obligation. It can be specified in job descriptions. It can be specified indeed in the codes of governance. But it's also informal expectations, since those to whom I am accountable or who are accountable to me will be understand their accountability by the way in which our relationship develops. There is also a voluntary choice exercise, which is that one may emphasize one's accountability, for example, to the sense of public interest, or one might emphasize one's accountability for ensuring the corporate success of the organization, which is beyond the formal obligation. And the importance of accepting responsibility and understanding that one has to account for one's actions to a third party is a fundamental aspect of accountability.
Thank you. And then from paragraph 2.2 onwards, that big bold heading, board accountabilities arising from the corporate code, do you set out right up until page 30 the elements of a corporation arising from the corporate code and describing the accountability responsibilities of each of them.
Indeed we do, and so we begin there with the board as a whole.
And then if we go over the page, please, at the foot of the page 22, you deal with board committees.
Indeed.
And then if we go on to page 24, you address the accountabilities of and to a chair of a board.
Correct.
And then page 27, non-executive directors.
Correct.
Over the page, SID or senior independent directors, and then at halfway down the page, the chief executive. Then to page 29, other executive board members, the chief finance officer, etc. And then at the foot of the page, the company secretary.
That's correct. And with regard to the other executive board members, it particularly says, for example, because they won't necessarily be on the board, but if they were, as an executive director, this would be their duties and accountability.
And does it follow that in the pages we've just looked at, that is essentially not you speaking, this is, i.e. the pair of you speaking, this is you explaining the elements of the corporate code speaking?
This is indeed that basis. We haven't invented these.
No, exactly. And so these are references to the accountabilities of each of the organisations or things or individuals by reference to an instrument which the post office ought to have abided by or explained why not.
Yes.
Just one question on the detail of what you have narrated there then. Page 27, under the heading non-executive directors. And you divide into A and B, two groups of NEDs.
Yes.
What you describe as INEDs and NINEDs.
Yes.
I think this is a distinction that we may not have come across in the inquiry. Can you explain, please, the difference between INEDs and NINEDs in simple terms, if you could?
Yes. INEDs are independent non-executive directors. They are appointed for the purposes of the fact that they are independent, and they will bring that independent perspective as well as their specialist relevant expertise to the board. Some non-executive directors, that is, they are not executives responsible for running the company, are not in fact independent NEDs, INEDs, they are NINEDs, that is, they're non-independent non-executive directors. And non-independent non-executive directors have already got some link to the company or the corporation. They can be nominated by the shareholders because they've got a special relationship with the shareholders. And in the case of before the inquiry, there are examples of the shareholder appointing non-executive directors, and they would be NINEDs, or they may have had a previous executive position in the organisation, and they move from an executive position to a non-executive position, but they're not independent because they're utterly steeped in the company. They may indeed have been responsible for developing various aspects of its strategy or operations, so they cannot be seen to be independent, but they are thought by the boards of those companies to have such special expertise that they wish to retain them as a non-executive director.
And so within that categorisation of NINEDs, we're concerned with the first of them,
You are.
as you've explained, namely nomination by shareholders, in this case the shareholder, the government. Did that nomination occur both when SHEEX and then UKGI were the level 3 intermediary?
That is correct.
Are there any different duties that apply to a non-independent NED as opposed to an independent NED?
All directors of the board are governed by their individual and collective responsibility as directors, and they share that responsibility as directors. Ordinary, one might say, non-executive directors are there for the reasons given above. Non-independent non-executive directors are there for the reason of being a director, but also to keep the shareholder regularly informed about matters of concern, to keep the shareholder in touch with what's going on with the business, to consult with the shareholder on major decisions, and to ensure a two-way channel of communication between the board and the shareholder. They also bring their specialist expertise. So there is a difference.
Do they fall to be treated any differently by the balance of the board?
The way any board operates is very much open to the interpretation within the bounds of the guidance by the chair and the board collectively. In my personal experience, occasionally there will be matters where it is thought that their particular shareholder interest may make it inappropriate for them to continue with the discussion, and they may feel a conflict or their particular position requires them to absent themselves, or they may indeed be asked to absent themselves. In my experience, that's comparatively rare, but the very fact that they have a particular relationship with the shareholder may mean that there are times when they are not party to certain board discussions. Apart from that, they are fully members of the board.
Thank you. Can we go on, please, to, after checking that point of detail, to page 30? This is the next big heading in the report concerning the role of the shareholder. And then if we look over the page to paragraph 2.4, the role of the executive, and then over the page to paragraph 2.5, strategy. Can I just check the status of those big paragraphs? Mm-hmm. That's essentially you speaking, the pair of you speaking, is that right?
With regard to the role of the shareholder and the role of the executive?
Yes, and strategy,
and
as
strategy.
Opposed to being drawn from codes.
Well, the role of the shareholder is implicit in the whole of corporate governance codes. And so one would say that that's not entirely us speaking, because the role of the shareholder is a driver, as we say, a quiet driver of governance to hold the company to account for what they're doing with their assets. Hence the reasons that one has annual reports, one has annual general meetings and so on, in order to allow the shareholder to question. I think that in the mind, for example, of Adrian Cadbury, going back to the beginning, there was a feeling that shareholders should be more active in holding companies to account. And so in many of the codes and their revisions, the role of the shareholder is identified as an area of expectation. So the role of the shareholder is both our view plus informed by the way the codes have developed.
Thank you. Could we move on from chapter 2 to chapter 3, which starts at page 36? This addresses monitoring and audit. Again, can you help us, please, by summarising the purpose and coverage of this chapter?
Throughout the development of corporate governance, it's been understood that the way information is sought about what is going on in the company means that there should be appropriate means of auditing and monitoring that activity. and executives are required to and expected to monitor and report on financial flows in and out of the company, including verifiable data to show such things as tax liabilities and payments, turnover, expenses and profits. So we're expected to show what they're doing with the finances. Executives need to be held to account, and these are the processes by which executives are held to account for the using of the assets. It then developed in terms of requirements for boards and executives to assess risks to the company, and specific relations to risk arose out of audit and then, as it were, assumed a role of its own.
Thank you. I've got no more questions on chapter 3. Can we move to chapter 4, please? Page 47, where you indeed address the topic of risk. And again, can you help us by summarising the purpose and coverage of that chapter, which runs up to page 54?
Well, as we indicate there, risk is a fundamental and necessary part of executive responsibilities. Historically, it was rarely designated as something specifically identifiable because it was simply seen as a key part of running the business. One couldn't run the business without awareness of risk. What has happened in terms of corporate governance is that the requirement for executives and the board to look very carefully at the identification of risks to their business and the way in which, once identified, those risks are monitored, evaluated, and proposals made for their mitigation has become an essential part of both governance and management.
Thank you. Just one question arising from chapter 4. If we can go to page 48, please, at the foot of the page. The text there in 4.2.9 and 4.2.10 seems to arise from an FSA statement of 2003, FSA being the Financial Services Authority. And I think that was an agency that regulated financial services in the UK between 2001 and 2013. And it then became it was split, and part of it became the Financial Conduct Authority, the FCA. To what extent should a company like the Post Office from 2003 onwards have regard to statements like these emanating from the FSA?
The Post Office handled financial services, and therefore it would be wise to pay regard to what the Financial Services Authority was actually saying about risk. But beyond that, the FSA became a leader for identifying risk, which then was taken into the Corporate Governance Code, and the FRC, the Financial Reporting Council, then took up some of those ideas. So this is relevant both in terms of it being a leader in terms of identifying risk, but also bearing in mind that the Post Office itself was in financial services.
Thank you very much. Can we move to chapter 5, please? Page 55. Governance and management of technically complex major projects. And I think you explain here that you, in 5.1.2, that you classified the introduction and rollout of the Horizon computer system as such a project.
Indeed.
Can you again help us with a broad description of the purpose and coverage of this section of your report, chapter 5?
We first of all felt that it would be wise to identify 3 characteristics of major project management: uncertainty, complexity, and scale, which can be found in relation to nearly all such projects, and that inevitably there are tensions and trade-offs which need to be made. And one can think simply in terms of three groups: time, cost, and quality or delivery. And it is in our experience the case that there are always these trade-offs, because there's never enough resource, there's never enough time, and you always want a better quality than you're going to get. So that's an inherent part of, as it were, their management. Another part of their management is the use of third-party suppliers, both in assurance and in provision, and we thought that that was relevant. We then go into the role of the executive and the role of the board in relation to what we see as critical aspects to be expected of their management.
And you divide that up essentially into what you describe as pre-go-ahead,
Yeah.
and then part of go-ahead,
Yeah.
and then once the project is underway.
Indeed.
Thank you. Can we turn to chapter 6, please, which is page 63. This relates to governance and management of whistleblowing. Although I've got no questions about this, can you explain why you included a chapter concerning the governance and management of whistleblowing?
It's become a fundamentally important part of governance that boards should make sure that they are enabling people who wish to speak up without fear of discrimination, and to speak up in ways that will be honest and transparent. And this has been something which has been significantly developed in terms of board responsibilities. And we felt that it was appropriate to look at both the role of executive and the role of board in relation to whistleblowing, as it is called. We relate that also to the behavioural and cultural requirements for effective whistleblowing. This is, for example, how one handles the communication, how one looks at the lived experience of whistleblowers, and whether they do in fact enable assumptions about what is accepted to be challenged.
Thank you. Can we turn to chapter 7, stakeholder management?
Before we do, just as a citizen, the word whistleblowing has come to my notice more recently, shall we say,
Yeah.
than, say, the year 2000.
Oh, indeed. And
Right,
I
so,
think
so in the period we're talking about, has the whole, how could I put it, the concept of whistleblowing seems to me, as a citizen, to have been developing over this period. Can I put it in that way? So that those responsible in 2000 might not have the same perception of those responsible now. Is that reasonable?
so when that is exactly the case, as is the case for quite a number of things that we're looking at, the concept of speaking up and the arrangements for ensuring that those who wish to speak up can do so freely has been very significantly developed over this time.
Fine.
Albeit, I think if you look at the foot of page 63,
Yeah.
you note in paragraph 6.2.2 that the concept of whistleblowing, even though it might not have been called that, was embedded from at least the mid-1990s in the ERA, the Employment Rights Act, 1996.
Yeah, and I'm very grateful to you for pointing that out, because I was thinking in my mind the Public Disclosure Act is very important in protecting workers. So workers had the right from that period. The response and what was seen to be the responsibilities by the executive and the board developed later, one might say. So the right was there, the arrangements were not always in place.
So essentially, I think what happened was the Public Interest and Disclosure Act, the Public Interest Disclosure Act 1998 amended the Employment Rights Act 1996, and we can see that from page 93 of your report. And just scroll down under
Yeah.
identical sections in 1.0 and 2.0. 0 that in 98, the 1998 Act introduced a law that protected what you've described as whistleblowers. It doesn't use those words in the Act itself, from negative treatment or unfair dismissal.
Yeah.
So the
Correct.
protection was there from at least before the relevant period that we're considering.
Correct.
But the nomenclature may have changed.
The nomenclature changed, and also the very specific requirements on boards, for example, to have a whistleblowing champion, which does come later.
Thank you. If we go back, please, to where we were, which is chapter 7 we were about to turn to, which is page 70. In this chapter, you deal with what's described as stakeholder management, which again may be a word or words that didn't exist in the late 1990s. Can you describe the purpose and coverage of this part of your report, please?
Yeah. I think stakeholders would have been very well understood in 1999. These are people, groups of people, who both believe and also, in fact, they have a stake or interest in what the organisation does, how it does it, and what it may do in the future. These may be internal stakeholders, employees, or elected internal representatives, for example, in trade unions, or they may be external stakeholders, customers, clients, suppliers, distributors. We give a whole list in 7.1.3. And the development of governance, but I think was very clearly there in 1999, is that boards of directors should, if they are interested, as they should be, in serving the best interests of their company, must have an understanding of what these key stakeholder groups are. Now, what and who is a key stakeholder group would be a matter for the board to decide, and sometimes their gaze perhaps falls more on one stakeholder rather than another. The one stakeholder that definitely has a direct impact is, of course, the shareholder, but we have used this chapter to talk about stakeholders beyond shareholders.
And I think you identify, in addition to the government and its representatives as owner, as a key stakeholder, Fujitsu as a key supplier, and sub-postmasters.
Indeed. And we did that because we felt those were three stakeholders that were perhaps of particular interest to the inquiry.
Thank you. And lastly, chapter 8, which begins on page 77. This runs from pages 77 to 92 and is headed Experience in Governance and Management. Again, can you explain the purpose and coverage of this chapter?
Yeah. Chapter 8 is different to the chapters 1 to 7, which have been constructed around the scaffolding provided by Annex A, paying particular attention to Annex B. In Section A, we take a different perspective, and we take a perspective which is more informed from our expertise in organisational behaviour than in the specific requirements of governance. And this is, well, what is it like to experience governance and management? And we do there look at authority, power, interest and conflict together, leadership, culture, and communication. Now, various elements of those are identified in governance codes. For example, culture becomes something which is very important in governance codes. But we, in this section, look at its experience.
Thank you. I have got no more questions on report 1. Can we turn to report 2, please? You remember the approach that we discussed at the beginning of your evidence session, namely you identified 3 case studies, and through those 3 case studies identified 9 themes. And in the first part of this report, you addressed the 9 themes, and then you turned to the case studies. I'm going to invert that order, i.e. consider matters the other way around, by looking at the case studies first, then looking at the themes, and then thirdly by exploring some very specific topics with you. So can we turn, please, to case study 1. That starts at page 42. Out of the pair of you, are either of you more expert or across the detail of any of the 3 case studies?
The way in which we approach these has been to work entirely together. We've discussed everything. We have come to our conclusions together. With regard to the first drafts of Mrs. Wolstenholme's case and the Simon Clark advice case, Dr. Steward did the first draft of those, which we then discussed entirely together, and I did the first draft of the second case on second sight. I think we're happy to proceed under option C, which is that you address questions to me, but that is the way in which we have constructed the cases.
Thank you very much. So can we look at case study 1, please? And your analysis runs between page 42 right up until page 54. And the way that you deal with each of the case studies is you set out an approach which sometimes involves a description of the facts. You then break down issues or isolate issues that arise in the case study, and then you ask a question and then answer it in a subheading conclusion under each issue. Have I got that right?
That's
Thank you. So if we start, please, with paragraph 150 on page 43. There's a very nice pithy summary in paragraph 150 of the case. Julie Wolstenholme was a sub-postmark mistress who ran a branch in Cleveleys, Lancashire. The post office pursued her for a £25,000 shortfall in the civil courts. During her case, a report by Jason Coyne into her system found Horizon was defective. Her branch had been closed down, but she pursued the post office for £180,000.
correct.
And then paragraphs 155, starting on page 44, right through to 160 on page 45, they set out, do they, your references to some of the underlying material that you have considered in formulating a view on this case.
That is correct.
And then if we move to 161 on page 45, we set out your conclusions.
Indeed.
And I'm going to take these in some detail in relation to each of the cases. You say, in your view, the Royal Mail Group General Counsel and the Post Office Chief Executive Officer must have understood from the exchange about Mrs. Wolstenholme's case that the Horizon system posed a risk to the validity of sub-postmaster branches and therefore to the safety of prosecutions on Horizon data, yet they did not act. Do I take correctly from that that you have sought to draw a wider conclusion arising from the facts in Mrs. Wolstenholme's case about the impact that it ought to have had on criminal proceedings, even though this was a civil case?
That is correct. Since the problems identified with Horizon were being used in prosecutions, and therefore that understanding should have been seen to be relevant.
In the spectrum of failures or criticisms, how serious a failure is this?
It's a failure to connect what was going on in the civil proceedings with read across to prosecutions And it was a failure to understand that here was material which suggested that Horizon was not bug-free, which could impact the use of that Horizon data in both civil and prosecution cases. The connections weren't made and action wasn't taken. So in this specific thing, one would have expected the connection to have been made.
In 162, you tell us that the Chief Executive Officer should have talked immediately to the Chief Operating Officer and the IT Director about the concerns brought into sharp focus by the risk of £1 million that was sitting on the risk register. Had he, that's the CEO, talked to the Chief Operating Officer in May, I think that's 2004, about the risk, it's likely that when the Chief Operating Officer was asked to sign off the significant settlement to Mrs. Wolstenholme in July 2004, he would have brought this to the attention of the CEO, something which he should have done anyway.
That's correct. He should have done it anyway, but the very fact that there was this prior knowledge should have alerted him to bring it into the executive discussion.
Over the page, please, to paragraph 163. You say that it seemed to the pair of you that EXCO, who are you referring to as EXCO there? Not by name, but
No,
by description.
that is the senior leadership team that the chief executive or managing director chooses to have as their most senior team.
They did not pool their piecemeal knowledge of emergent issues, and so opportunities to share and create a collective understanding of the risk were lost. What risks were you referring to there?
We were referring to the risk that the use of Horizon data in civil and prosecution cases posed risks for the post office business.
You tell us in...
Do you want to add anything to that?
No, that
You tell us in paragraph 164 that this was not escalated to the Post Office Board, according to the evidence of Sir Michael Hodgkinson, but I think it's your view that it ought to have been.
Indeed, it is.
And that was a failure, have I got this right, of the executive to do so?
Yes, to escalate.
Yes. You tell us in 165 that the independent expert evidence relating to the civil case against Mrs. Wolstenholme, i.e. Jason Coyne's report, should have been brought to the attention of the Chief Operating Officer when asked to approve the settlement, if he hadn't asked for it, and it should have been discussed at a board risk committee.
Correct.
And these should-haves,
Yes.
are they formulated on the basis of the reasonably expected principles of good governance that you've identified in Report 1?
They are, and they are also based, as we have said, on our experience. But they are based in the expectations that we've laid out in Report number 1.
You say that both the £1 million risk on the register and Jason Coyne's report should have been escalated to the chair, and that if he had known about these matters, he should have escalated to the group chair or to the Royal Mail Group chief executive officer, and that so far as you were aware, none of them were told about the case or its settlement. That
was our belief.
In 168, you described the questions that might have arisen, and over to 169, you say that you've looked at the board minutes and meetings of the Post Office Limited board. There was always a majority of executives over non-executives. Although there was movement to appoint independent NEDs, they were outnumbered by executives, and therefore a relatively weak base for independent challenge by way of viewing the business. Is this a linked point, or is this an independent point concerning the Wolstenholme case?
I think it's both linked and independent. It's linked because the lack of scrutiny which we have identified, one might have expected to be greater if there had been more NEDs available. The fact that there weren't NEDs available was not itself a failure of governance, because they weren't required at a time for this subsidiary organisation which was subsidiary to Royal Mail Holdings. So there wasn't a deficit in governance terms that there were no NEDs, but there was a practical result of there being few NEDs, that there was less challenge being made. I'm not sure if that answers your question of whether it was linked or separate. But
It does, thank you.
thank you.
In paragraphs 170 and 171, you tell us about what the Post Office Board's focus was
Yeah.
at this time. Do I understand you to say that in these paragraphs that it was because of the focus that this may have been missed, or you simply don't know?
We're pointing out that these matters did not get an airing. And we are also pointing out that there was a strong emphasis upon survival, on new products and growth, and that, it seems to us, led other matters which could be seen to be operational as not being the subject of interrogation at the board.
And so that is, I think you've in fact come to a conclusion at 172 in the first sentence. If the Chief Executive Officer had acted differently, then a collective understanding within the Post Office Executive could have been developed. And then the following things that you identify, you think ought reasonably to have followed.
Indeed. And we also identify that these risks could have been made explicit in a whole different way of a whole variety of ways. It could have been the one-to-one conversation, it could have been the board risk register, it could have been the risk and compliance committee, it could have been discussed with the chair. The truth is that it was did not feature in any of these forum.
And so that's issue one under Wolstenholme. What in particular should the CEO have done when receiving the email relating to Mrs. Wolstenholme? You then turn, if we go to page 48, to the second issue that you isolate as arising out of the Wolstenholme case, namely the relationship between the Post Office as a subsidiary and the Royal Mail Group as a parent holding company. Can you help us? Why did you address this issue in relation to the Wolstenholme case?
Because we were making the relationship earlier between what was going on in the civil cases and what was going on in the criminal cases. And the legal function for the Post Office was not independent. It was a centrally held function by Royal Mail Group, or however it was addressed at that point, I mean in terms of its name. And therefore, the responsibility for interrogating the way in which prosecutions and indeed civil cases were taken actually lay formally with Royal Mail Group. Nonetheless, Post Office understood that they were they had some responsibility because it was conducted in their name. But nonetheless, Royal Mail, as the parent holding company, was the overall group responsible for prosecutions and civil cases. And their general counsel, the Post Office didn't have a general counsel at that time. It was the RMG general counsel who was, as it were, responsible here.
Thank you. And can we turn to your conclusions on this issue, which are on page 50? You say the way in which Post Office related to RMG added to a situation in which matters concerned with prosecutions went without challenge at the Post Office Board. By the time Sir Michael Hodgson, the chair, left in 2007, ownership for reporting to the Post Office Board on prosecutions was not established, and processes for monitoring horizon risk, prosecution policies and practices, whistleblowing, sub-postmaster feedback do not appear to us to have been in place. The board of Royal Mail Group paid little attention to post office business operations, even though their group functions, for example, legal and HR, were responsible for functional management in some areas of post office. The post office chair should have been told of the IT risk facing post office of £1 million. This risk should also have been escalated to the RMG board directly or via the Risk and Audit Committee. The link between horizon risk and prosecutions is very clear in the Wolstenholme case, even though not a criminal case because of the COIM review. This link should have been discussed by both the Pole executive and the board, and should have raised enough concerns about the inherent risk in conducting prosecutions based on horizon data to warrant discussion between the Post Office Chair and the Royal Mail Group board directly, or via the Royal Mail Group CEO. Those are your conclusions on issue 2. Collectively, how serious a failing are you describing here?
I think it's a failure of accountability, because there is no doubt, as far as we could see, that RMG had this overall responsibility, and therefore they should have ensured that what was going on in Pole enabled that responsibility to be secured. It was, in a way, their choice. They had a central function. They could have said to Pole, down to you, you make sure that you are monitoring these risks, that you are understanding them, and so on, because we want you as a subsidiary to do that. It seems to us that that was not done. That doesn't excuse the Pole board and executive from not picking them up, but one might think that they would have thought, well, this function doesn't lie with us, it lies up there. So with regard to how serious, I think it is a serious failure to understand the responsibilities of a holding company, the responsibilities of the subsidiary company, and above all, for those two to sort out appropriate arrangements for risk and for monitoring.
You mentioned that in that last answer that it doesn't absolve the Post Office Board of responsibility, the failures you described. You turn to that in issue 3. Can we turn to that? It's page 51. This is the third of 3 issues that you identify in the Wolstenholme case. You tell us in paragraph 187, the board and executive should understand their role in creating culture in the business and in the boardroom, including challenge, curiosity, and looking for the bigger picture. At 188, the board at the time of Mrs. Wolstenholme case was not a full board for reasons that you had identified, i.e. because of the strong non-executive, or the absence of a strong non-executive presence. And then if we go over the page, please, to 193, you set out your conclusions between paragraphs 193 and 196 in relation to the Pole board culture when addressing the Wolstenholme case. You say there was a lack of focus on prosecutions at the Post Office Board, which was, in your view, a reflection of the embedded Post Office culture. Can you tell us what the foundation for that is, please?
It is from both transcripts and witness statements that we have read, which talk about the fact that prosecutions was seen as something that the Post Office did. It didn't feature, for example, in the induction to new board members. It was seen to be non-problematic, and indeed a very important part of the Post Office defending its public duty and its public right to defend Post Office monies, which were the public's monies. So there was an embedded view that it was an accepted part, and it appears to us to have been accepted that it was done in a due process. Would you like to add anything to that?
I mean, we heard numerous times during the testimony that people weren't aware of the whole that RMG did prosecutions. So I think that's the basis of the finding that it was deep in the culture that Pole wasn't, if you like, had a clear sense of ownership, if you like, over the prosecutions.
It was just something that happened.
Exactly.
It appears to be something that happened.
In 194, I'd like you, if you could, to explain the first sentence, that Post Office executives failed to conceptualise the operational problem of faults in Horizon as a risk factor. What do you mean, failed to conceptualise?
Well, they didn't imagine it. They didn't think about it. They thought that they were dealing with a technology system, and were there problems, as far as we could tell, were there problems with that technology system, that relationship to what was going on in the routine business of prosecutions defending public money was not connected.
I see. So meaning that they failed properly even to think about it.
Yes, they failed to conceptualize, they failed to think about it.
If I might, I mean, the way I see that is that there were in the executive team at least 4 functions who were aware of, or could have been aware of, the Coin Report. Finance function, the IT, it was on the IT risk register, the operator, chief operating officer, the chief executive. And had at that point there been a conversation between those 4 functional leads about, what do you know about the Coin Report? What's this telling us? Is this telling us that we have an issue with technology, or is this telling us that we have an issue with prosecutions? Then you can see how that conversation would have developed into a broader conceptualization of the role that Pole had in conducting prosecutions, and the technology is being at the heart of that.
Thank you. Paragraph 195, you say and I think that's the failures you've mentioned in the previous paragraphs, were exacerbated by a lack of challenge to the Post Office executive. The governance of Post Office was in embryonic form. Can you explain what you mean by that and why you say it?
In embryonic form, we mean that there were, as we've seen, there was a non-executive chair, and there was the first non-executive by this time appointed. They were getting their feet under the table, understanding Post Office business, and they did not challenge what was an accepted, taken for granted, and they didn't say, well, what's the real problem beneath this information we're getting about Horizon? Does it have implications outside the civil context? Because this, of course, was a civil case, such as for prosecutions. Now, one might say, well, how could they do that if they weren't told about it? And that is a recurring theme we've found in the cases that we've looked at. Nonetheless, the Post Office chief executive was a member of the board. The Post Office chief executive did have a relationship with the independent, the non-executive chair, and it could have been challenged, and it wasn't.
Thank you. Can I ask you, Dame Sandra, just to move the microphone? As you've moved to the screen,
Right.
You've moved away from the microphone, and as you've warmed to your theme, you've sped up a little bit.
Right.
If you could slow down a little bit when giving your answers, we'd be grateful. That's my fault for not properly controlling your evidence. In paragraph 195, you set out some questions at the end of the paragraph as to questions that might have been asked. And you identify in paragraph 196 that although Royal Mail Group acted as a challenge to the Post Office in some areas, prosecutions was not one of them.
Correct.
Looking at this issue, the third issue, the culture of the board and the failure properly to challenge by the group, how serious are the series of failings that you identify here?
I'm sorry,
Yes.
can you repeat?
Looking at paragraphs 193 to 196,
Yeah.
in the scheme of things, in the spectrum of seriousness of failings, where does this sit? I realise I'm asking you on every occasion to pitch on a spectrum,
Yes.
and that's because you don't do so in the report.
No.
And that may be because you're unwilling to do so, but I'm asking nonetheless.
We are willing to help the inquiry in any way we can. We haven't come here with a sort of measure of failure. What we've done is identified failures which we see as being germane to the interests of the inquiry. Many of these matters are individual issues, individual events, which if you add them all up, you would say that's a failure to know something, to connect with something that we already know, and for us to take a view on. This is one such matter. If it was alone, then the governance system, one could say, was quite robust. But because this, as we will see in relation to other things, this neglect of seeing the risk inherent in prosecutions in relation to Horizon, this is part of what we see to be a general failure.
You set out your overall conclusions on the Wolstenholme case study in paragraphs 198 to 205. And here, are you essentially drawing the threads together in relation to the Wolstenholme case?
We are trying to do so.
Thank you. And could you talk us through then your views when drawing the threads together in the Wolstenholme case?
Yes. Firstly, that Pole prosecution's policies and practices didn't have priority for either the RMG or for Pole. Furthermore, there is a lack of clarity about if they had looked at it, who was really responsible. So we think neither of them gave it priority, and the lack of clarity probably exacerbated this matter, the lack of clarity on who had oversight of prosecutions. The Pole board was largely made up of executives, as we've talked about. There was little independent challenge. It's not unusual for there to be little independent challenge at subsidiary boards because it puts then greater responsibility on the holding company to challenge. But that would have required, if I can elaborate on this, as I said earlier, that would have required there to be a clear agreement about, well, with regard to post office prosecutions, who is really going to monitor and oversee this? And there wasn't that clarity. The Coyne report, an independent specialist, was neglected. But what's more, we haven't seen any evidence that there were independent specialists to advise the Post Office Board on key areas of technology and legal. That was especially important because of the lack of independent challenge and advice one might get from non-executives. We then go on in 201. The risk wasn't elevated, as we've already talked about, and it should have been. There was a lack of focus on the prosecutions on the Pole board, and the whole risk system seems to us to have lacked a coherent framework for risk identification, evaluation, and escalation, particularly in the connections that could be made between Horizon and prosecutions.
Just stopping there on that, the sentence, or the part of the sentence which says the whole risk system seems to have lacked a coherent framework for risk identification, evaluation, and escalation. That's in a sentence which you've just spoken about. You said, in particular, in relation to prosecutions. Does that conclusion apply more generally?
We have looked particularly at the aspect of prosecutions and Horizon, and we haven't looked at risk identification in relation to other areas. I think I'm
Not specifically.
not specifically.
notes. I mean,
Yeah.
there could be all sorts of other things like
There could be. Insolvency.
insolvency or manual handling by employees,
There could
or
have been.
injuries to members of staff on duty, or
There could be.
that kind of thing.
Yeah.
So this is particularly in relation to the conduct
Yeah.
of prosecutions.
And I guess that relates to the opening of that sentence. There was a lack of focus at the poll board. So lack of focus on prosecutions.
Thank you very much. And then over the page, please. You tell us about a missed opportunity by both the executive and the board in 203.
I think this is exactly the point you were making earlier. Do you want to add anything to it?
I think we've made the point that actually there was an initial moment when things could have turned out very differently, perhaps. Had the conversation happened in the executive team, had that then been elevated to the board, had that then been discussed with the chair, had the chair then discussed it with RMG or the routes through to the RMG audit and risk used. Then
Thank you. And then skipping to paragraph 205, you set out your views on the attribution of responsibility, and really it's a two-pronged conclusion that
Yeah.
it was the responsibility of RMG to identify and manage these risks. Is that right?
Indeed.
Because
that is.
it was the parent holding company, but in fact, functionally, it carried out the conduct of prosecutions.
Yeah. And had they wanted it to be held at the level of the post office, that could have happened, and it could have been clear in delegated duties that that was the case, but that did not, as far as we know, happen.
Overall, how significant was the relatively early episode of the Wolstenholme case, being in 2004, to the issues which you examined?
I think it's significant in retrospect as we look at it, because it seems to be that this pattern is repeated. At the time, I would say it showed, with regard to prosecutions, that we had an executive team and a board that were not paying attention to the risks posed in prosecutions dependent upon horizon data. And that is a neglected risk throughout the story of this inquiry.
Thank you. Can we turn to the second case study then, please, which is the second site interim report and the consideration of it by the Post Office board in July 2013. That starts, thank you very much, on page 55. And this is a much longer analysis. It runs right through until page 108 of your report. Can we read, please, paragraphs 212 to 214 on pages 56 and 57, which are essentially a short summary of the episode. You call it the context of the case, but it's a good primer.
Yeah.
Second Sight was appointed by Post Office in mid-2012 to carry out a review into the alleged problems with the Horizon IT system. The inquiries heard that the appointment was in part a response to increasing pressure from James R. Buthnott and other MPs, persistent critical questions from investigative journalists and ministerial interest. The appointment of Second Sight was handled by the Post Office executive with very little board involvement, apart from that of the chair. The inquiry has heard that the terms of reference were subject to several iterations between the parties, and no formal letter of engagement was ever signed. Second Sight summarised their appointment as follows, and you set that out. And then 214, the board met via conference call on the 1st of July, received their first very brief account of the work from the Post Office Chief Executive Officer. They were told of the imminent publication of the Second Sight report. The report was published on the 8th of July when it was made available to the board. The board received an update paper in the light of the report at their meeting on the 16th of July. Were you essentially, therefore, considering the period up until but not after the 16th of July?
that was our focus. Our focus was very much on the preparation for publication, the publication of Second Sight and its consideration at that board. As we'll see, there were a few matters that we felt we should extend our concerns with, but in the main, that was it. It's a case of the board's handling of the interim report of Second Sight at that time.
And then if we can look at the top of page 56, please. I think if we just pan out a little bit on the screen to the top half of the page, thank you, we can see that you isolated 9 issues arising from this episode. Is that right?
That's correct.
And they're listed there as issues 1 to 9.
That's correct.
And what I'd like to do, if I may, is go to the conclusions which you reach in relation to each of the 9 issues, rather than examining the run-up to those conclusions in each case.
Absolutely.
So in relation to issue 1, can we look please at page 58, paragraph 217? We should identify what issue 1 was. Just look at page 57, please. At the foot of the page. Issue 1, the priorities of the board in July 2013. And then if we go forwards, please, to paragraph 217 on page 58. You say the findings of the report contain sufficient information to warrant the board giving priority to getting a stronger grip on Post Office's investigations and prosecutions policy and practice, particularly but not solely when Horizon data was used. The board should also have been paying attention to what they were being told by Second Sight about Post Office's attitudes and approach to sub-postmasters, particularly as it had resonance with what was becoming a familiar refrain from investigative journalists and MPs. You had not seen evidence that either the executive or the board saw those issues as priorities. And so can you expand upon or explain the conclusion that you reached there? This is about prioritisation.
It's about, yes, where the gaze of the board was falling. It was falling on brand and reputation. It was falling on securing government agreement for ongoing funding. It was focused on getting government support for the strategic plan, which was connected to funding. It was helping RMG prepare for privatisation, and it was continuing to create the Post Office an independent business separate from RMG, in which they had to build their own standalone governance structures and central functions. All good priorities. But at the same time, there was as we've indicated, media, ministerial, parliamentary interest and identity of what, on the face of it, appeared to be serious problems in the use of Horizon data in prosecutions. This, as far as we could see, was not a priority for the board at all.
Issue 2, please, over the page at the top. Perceptions of the Horizon system, Second Sight and Post Office prosecution policy and practices, and of sub-postmasters. And can we look at your conclusion, please, on that issue? Page 65, paragraph 238 onwards. You tell us in 238, it goes right to up to 242, that the dependence of prosecutions on Horizon data was not articulated as a concern by either the executive or the board as they approached the discussions of the report on the 16th of July. So taken were the executive with their sense of mission, their distrust of Second Sight. They did not take the advantage of having an independent reviewer in their midst who was offering various bits of evidence which could have shaken their firmly held perceptions Not surprisingly then, they did nothing to alert the board that serious issues were being raised in the second sight report. I'll ask the question that I've asked a number of times. In the spectrum of importance or significance, where does this sit?
I think it's a serious failing. Here was an independent reviewer that they had deliberately brought in, and yet they were approaching it from a position of fairly fixed views that Horizon was robust. That they formed the view that Second Sight weren't really independent and were partisan. They had fixed views about sub-postmasters, and they had fixed views about the importance of their prosecutions, which they thought were being conducted, one assumes, appropriately. This meant that when these bits of information came in from the Second Sight review, and as we'll see later, they don't come in a sort of well-capsulated way, but they come in nonetheless, that they simply aren't identified.
And you expand upon that in 239. I think you largely covered that in your previous answer.
Yeah.
In 240, you explain that there was no challenge in July 2013 to the accepted view that any problems with the operations of Horizon lay with the people rather than the technology.
Yep. Yes, correct.
Could you ascertain why that was? I.e., there was no challenge.
What was the first part of your question? Could
Yes,
we?
You say there wasn't a challenge to the accepted view,
Yes.
and yet here was a report that arrived that did challenge it.
Yes.
Why was there no escalation by the executive or mere acceptance by the board of the executive's perceptions?
I think that's a $50,000 question. Why was there no challenge? There was no challenge, and we in this part tie it to the fact that they were concentrating on and looking at things in a way that made them blind to the pieces of information that were coming forward.
And is that the basis on which you form the conclusion at 241, last sentence, that the board did nothing to provide a corrective challenge to the executive's defensive position?
Yes, I see we did encapsulate what I was just trying to say, that
In
the
241.
belief of Horizon was robust, Second Sight was independence was questionable, policies and practices of investigations and prosecutions didn't warrant urgent investigations, and a tiny minority of sub-postmasters, as before the introduction, were guilty of misappropriating public funds. The board, as we shall see, many of them did not appear to appreciate how the post office was approaching investigations and prosecutions. And although they asked questions when pieces of private eye came out or so on, when told that there's nothing in this, Horizon is robust, they did nothing further to question, and I think we go on later to show how they might have questioned it.
Thank you. Lastly, on this issue, paragraph 242, you make the point that the Horizon system and post office prosecutions were seen as operational matters to be left to the executive. Is that seen by the board as operational matters?
It is, and probably by the executive too, and perhaps this is relevant to make the general point that in governance codes, in expected understandings of government, the role of the executive is to run the company. If they're a building company, to do the building, if they're and to ensure safety precautions. If they're a financial services company, to offer financial services. They run the company, and in operational matters to do with running the company are the executive responsibility. The board has a responsibility to oversee those operational matters, to ensure that they are being appropriately undertaken. But if you assume that everything's going fine, then it would be inappropriate for the board to inquire into operations. I don't know if you'd like me to go on to circumstances, it might come later, where the board would be expected to delve into those operational matters. But I guess what I'm saying is if I'm sitting at a boardroom and I'm a non-executive director and I regard a particular aspect of the company's operations, in this case, investigating and prosecuting sub-postmasters, if I regard that as a matter that's always been done, that's part of regular operations, that doesn't excite any particular mention, then it's legitimate for me as a board to leave the executive to run that.
You say that the irony is that what was seen by the NEDs as operational matters were in fact the basis of existential risk.
Yeah.
When you say irony, do you mean that... what do you mean?
I mean that they got it wrong, that they saw that it is operational and therefore nothing to do with them, but in fact it contained existential risk to the company and therefore, and untold suffering to sub-postmasters. And therefore, if only they had said, perhaps these aren't regular operational matters, perhaps we should have inquired into that, they would have revealed the extent of the risk that was there.
You say that more such curiosity and challenge may have dislodged the blindfold. Who was wearing the metaphoric blindfold?
Well, I think both the executive and the board were wearing a blindfold.
Thank you.
And that blindfold we relate here to the perceptions that we have just identified.
Thank you. So that's a convenient moment. May we break now until 1:45? Thank you.